Corla, I very much welcome the Spent Convictions Bill, which will allow for ex-offenders in their reintegration into society, where the sentence they were handed down is under six months imprisonment or a fine. The conviction under certain circumstances can be regarded as spent. I also very much welcome the thoughtful contributions of a number of different parties, the Irish Human Rights Commission and the Irish Penal Reform Trust, which will be reflected in the bill that is before us. This bill, Corla, is very much a step in the right direction for citizens in Ireland and for Ireland's standing in the world. Ireland is almost unique in the European Union in lacking legal provision in this area. Considering that the largest proportion of those who were sentenced by Irish courts receive short-term sentences, fines or community-based sanctions for non-violent offences, the lack of a possibility to have a criminal conviction deemed spent for a period of time is a consequence that is disproportionate, and it can be argued that it constitutes an additional punishment that lasts a lifetime. This situation has far-reaching consequences for those who are sentenced for criminal offences. Individuals with even minor criminal convictions face ongoing restrictions and barriers in employment, in training, in education, travel, and in taking out insurance, and in many other areas of life. These are people who were convicted of relatively minor offences many years ago and who have had no contact with the criminal justice system since then. Some have moved on to good careers, but still feel that perhaps their convictions are hanging over them. Others fear that if they try to move their job, their past will come back to haunt them. These are people who have made mistakes at an earlier point in their lives and were convicted of relatively minor offences. The Minister said that he had been struck since taking office at the number of people who have written to him urging the progression of this legislation. Indeed, I've recently been dealing with a case of a constituent, a young man who is having difficulties getting a visa in a non-European jurisdiction because he has one conviction from almost a decade ago which resulted in a fine for drunken disorderly behaviour. And in these difficult times, Corla, we have sadly to watch our young people immigrate. It is surely only fair that when a person immigrates, they are able to move on with getting their life back on track and not having an old conviction for a minor offence continually haunting them. All of that said, there does need to be a balance in the legislation, and there are a number of points to be made in this. Firstly, that a person should, after a reasonable period of time, be able to move on and not have to declare the fact of a previous conviction for relatively minor offences, particularly when applying for a job. This is the point of the legislation, that our criminal justice system not only punishes where appropriate, but that it also rehabilitates where appropriate as well. The second is that certain offences, such as sexual offences, must always be disclosed, no matter the length of time the prison sentence imposed or the amount of time since the release that the person has been free of convictions. The third is that certain sensitive types of work, such as working involving children and vulnerable people in society, work in the field of justice and in state security, should be excluded from this legislation. I think the final 2 points support employers. No employer should be expected to operate in the dark and risk the reputation of his business as a result of the introduction of legislation of this kind. Neither can we put at risk vulnerable persons. This is why only minor offences are considered in the legislation and sexual and other offences are excluded. This is in the interest of the public and also in the interest of the state itself. The public must be able to feel safe in this regard, and to that effect the proposal in relation to spent convictions would undermine the legitimate requirements that those who wish to work for the state in sensitive roles or as providers of care will still be subject to vetting. The Government Bill explicitly provides that An Garda Síochána may disclose spent convictions where information is requested by an employer in respect of an excluded employment. For the avoidance of doubt, Corla, I would again like to repeat that individuals convicted of sexual offences would not be able to benefit from the provisions of this bill. There cannot be any allowance in this regard, and I think the bill makes that crystal clear. This bill is fundamentally about people with convictions gaining access to employment. I've already stated that it's necessary to preclude some types. Finally, on this issue of excluded employment requiring, I want to say that this should not mean somebody convicted of an offence that will be spent where the job is in a field where a conviction will be deemed as spent should be debarred from employment. Reasonable employers should consider if the conviction is relevant to the job on offer, and where it is not, should not allow it to influence their decision. Prospective employers have a key role to play in the rehabilitation of offenders, including their integration into the workforce. And I said earlier, this legislation supports employers, but this legislation should also support employees. Thank you.